Hi, I'm Edwin Colfax with the Texas Indigent Defense Commission, and our agency was directed by the legislature during the last session to conduct a weighted caseload study. And the study is designed to provide an objective basis for documenting the resource needs for court-appointed cases in the criminal courts in Texas. As part of our effort to implement this legislation and conduct this study, we've assembled an advisory panel of national and state experts who can provide us with the kind of guidance we're going to need to undertake this very difficult endeavor. And today we are here with Steve Hanlon and Peter Sterling, who've been very involved in a project in Missouri that does just that. It tries to document the resource needs carefully for various types of public defense cases in that state. And we're very much looking forward to their input as we go forward with our study.
Steve Hanlon, and I, for the last 5 or 6 years, have represented the Missouri Public Defender in its caseload litigation. And probably the most important thing that happened in that 5 or 6 years was we got a decision out of the Missouri Supreme Court that said when we have too many cases, we should go to the judge and say, we can't take any more cases right now, and you're going to have to find somebody else to represent this man. As we started to move forward on that, the state auditor, who was doing a routine audit of the Missouri Public Defender, said, well, it's obvious that you have way too many cases. Your funding has been flatlined for the last 10 years, and your caseload has dramatically increased for the last 10 years. But you don't know where to draw the line because you're not keeping your time all the time. So we said, you're absolutely right, Mr. Auditor. And in fact, a couple of months ago, we already made the decision, and now all of our lawyers, 335 or so it's a large public law firm in the state of Missouri, very centralized systems, different than your system here in Texas. But all of our lawyers now keep their times in fractions of an hour. It's basically a quarter hour, and take it all the way down to 5 minutes if we need to. And they're doing it without incident. It was an easy thing to do once they understood what the benefits are in terms of budgeting, in terms of operations, and in terms of ultimately showing where that line is, where if you have too many cases, you've got to say, Judge, I can't do this anymore because I can't violate the rules of professional conduct and the United States Constitution. So timekeeping is essential for this process, for all three of those reasons. It frankly is mystifying to me why public defenders for the last 40 years have not kept their time. They seek millions and millions of dollars in public funding, and they're frankly hiding the ball. And you can't successfully obtain public funds and not tell the public what you're doing, especially when you've had the capacity to do that and the technology to do that for at least 40 years. So it's somewhat of a mystery to me why we can't get that done, and I sure hope you're going to be able to get that done here in Texas, because it will dramatically increase your credibility in front of the legislature, in front of the courts, and it will dramatically increase your ability to operate effectively as counsel.
Peter Sterling, and I'm a career Missouri State Public Defender. Texas has put together this advisory panel that the Texas Indigent Defense Commission to put together the time study, and I'm here because I'm a public defender, I think, that has survived actually 2 time studies. The public defender system, in its first attempt in 2006 to create data to go to the legislature, conducted a time study. But after we did the timekeeping portion of it, the legislature told us they didn't really want any information. They believed we had a problem, and so we never completed the study. The part that we never completed was the Delphi part that takes the time public defenders are able to put into a case and then analyzes how much additional time is necessary to do the case right, because public defenders in Missouri are triaging their cases left and right. In other words, they're cutting their services to some clients in order to provide services or to prepare for the trials of other clients, which is, in my opinion anyway, grossly unconstitutional and unethical. So 2006, we got halfway there, and then we've worked ever since, and with Steve Hanlon's assistance, we've come close a couple times, but we never got the two pieces that are necessary in order to create an accurate caseload standard. You need time study data, what's actually going on, and then you need a Delphi process in order to analyze, using attorneys, experienced attorneys from the private bar and the public defender system, to analyze how much time things should take and how often they should occur. And this is what we're so appreciative to Steve and the American Bar Association for bringing to Missouri throughout this year. As Steve suggested earlier, this time around we're staying on timekeeping because it will provide a wealth of data, and data evolves just as the practice of law evolves. We are confident we will have data that will support future resource requests because it's current and it won't be criticized for being out of date or something like that.
My name is Dottie Carmichael. I'm with the Public Policy Research Institute at Texas A&M University. A weighted caseload study basically asks attorneys to track their time for a period of 12 weeks. At the end of the time period, we have a good measure of the amount of time that they're expending on a variety of different case levels. That data is then reviewed by a panel of experts who can make recommendations for adjusting the use of time to be higher or lower depending on factors about a case that would increase the investment of an attorney's time to achieve effective counsel. The benefit of a weighted caseload study is it quantifies attorneys' investment of time and makes it possible to make sure that they're fairly compensated for that effort. So it's a great way to justify and provide an evidence base for increasing investment in our state indigent defense system. As we've begun to lay the framework for the study, we've had the benefit of getting lots of assistance from a number of valued partners. One of these, of course, is the State Bar of Texas, as well as the Texas Criminal Defense Lawyers Association, and they have both opened their open their doors to us to help us get the word out to attorneys about this opportunity and to help understand the potential and the benefit it offers for Texas. We have had national experts come in that in fact you may be familiar with the now legend book, Securing Reasonable Caseloads, from Professor Norm Lefstein from Indiana University. Among others, Steve Hanlon from Missouri has spoken on their experience, and in addition to national experts, we've also had the benefit of input from practitioners who have really managed the effort of timekeeping in other states. And last but definitely not least, we have been collecting a lot of valued input from actual Texas criminal defense attorneys, and we hope to continue to keep them engaged in the process in the coming months. At the end of the day, a weighted caseload study is beneficial both for helping us understand the investment of effort required to provide effective representation and for providing an evidence-based rationale for determining fair compensation for that work.